everyone. In the last class, we have discussed about certain extent of the TP Act, Transfer of the Property Act. And today's class, we are going to discuss more on the same. Okay. So first of all, we have discussed about the interpretation clause of the TP Act in the details in the last class. The first interpretation clause, it speaks about the immovable property, which does not include the standing timber, growing crops, or grass that we have discussed in the last class. Then, coming to the next part, we have discussed about the instrument, and I have explained you the instrument specifically means the non-testamentary instrument which is not hereditary or testamentary in nature. That is, we have already discussed on this that what is testamentary instrument, that which comes from a generation to generation through the heredity wise. That, for example, I am getting a property from my forefathers, from my grandfather, from my father. Okay, that is called the property of the testamentary property or testamentary instrument. But the instrument which is non-testamentary is in nature, which is not herited from generation to generation, but it is being earned. That is called the non-testamentary instrument. Okay. Then the next part we have discussed, that is about the attested. Attested means we have discussed there must be the presence of the executant who is attesting the property, and there must be the presence of the two witnesses who either have seen all this process of the executant or any person on behalf of the executant, or if any witness is not present, he must have get the acknowledgement with the signature or stamp of the executant regarding the execution of the process. That is what we have discussed in the interpretation clause. Then we have discussed about the registered, something which has been lawfully registered with all the court procedure, or with all the rules, regulations. Okay, that is when we call the thing to be registered. Okay. Then we have discussed something which is attached to earth, means when certain kind of the property, movable property, that is collaborated with the earth, which is not separated from the earth, something which is rooted in the earth, embedded in the earth, attached to the earth. For example, there is a tree which is rooted in the earth, whose root is inside the earth. Until and unless this tree is being cut off from the root, has been converted into the wood, we'll call it as the immovable property. But at the moment the tree has been cut, or it has been cutten into the pieces and became the wood for our daily use materials, it became the movable property. Okay. So something whose root is inside the earth, which is embedded to the earth, your home, whenever we are making a home, its base is embedded in the earth, that is also considered as the immovable property. Okay. Then we have discussed about the actionable claim, that is upon the movable property. Okay, the debt upon the movable property or the interest upon the movable property, when it is being claimed, it is called the actionable claim. Okay. And the next we have discussed about the person to have the notice, when the person either have the knowledge of it, the person already know about this, or the situation when the person had the sufficient reason to know about it, the person has the sufficient circumstances, sufficient chances to know about this, but it is the irresponsibility of the person itself who has neglected the call and rejected it. For example, I had a sufficient opportunity to investigate into the matter, but I didn't do that due to my negligence. When due to my negligence I didn't do the investigation, then the thing or the result has come to be actually fraud, or I faced a difficulty. So in that circumstances, I would have called to have the notice of the fact or notice of the circumstances. But here, due to my negligence only, I am facing the losses over here. Okay. Then we have discussed the explanations. Okay. Then this is about the uh, section regarding the interpretation clause we have discussed. Then comes your section 5. Section 4, that is not important. Chapter 2. Chapter 2 speaks about the transfer of the property by the acts of the parties. That when the property is being transferred by the activity of the parties, by the acts of the parties. Okay, that is explained in the section 5 of the Transfer of the Property Act 1955. Okay, so let's read it out once. Section 5, what it exactly explains. In the following sections, transfer of the property means an act by which a living person conveys property in present or in future to one or more other living persons, or to himself and one or more other living persons, and to a transfer property is to perform such act. Okay, so when we are discussing about the transfer of the property, the question may arise, to whom the property can be transferred. किस किस को प्रॉपर्टी ट्रांसफर किया जा सकता है. ओके, फॉर एग्जाम्पल देयर इज माई पेट एनिमल. कैन आई ट्रांसफर द प्रॉपर्टी टू हिम? द आंसर इज yes, I can transfer the property to a pet animal. So for example, I am having a land, or I'm having a home, or I'm having a thing which is non-living in nature. So tell me, can I transfer the property to a thing which is non-living, which is not living in nature? The answer is no. The property can be transferred to the living persons only. The living persons can only receive the transferred property itself. Okay, it is the first provision. The second point, the living persons or to himself. The second part, to himself and the living person. So what does it mean? There is the difference, just differentiate the line. First it speaks when the property is being transferred to the living person or to himself. That means the property is transferred to the living person or to himself, or means either to the living person or to himself. The living person, it may include to anybody. I have property. This is my discretion to transfer whomever I want. This is my property. I will transfer it according to my choice, my wish. There is no one to stop me over here that don't do this transfer. This is my choice. Whomever I want to send the property or transfer the property, I will do the transfer. Okay. So here when we are talking about the transfer of the property over here, okay, in that circumstances, the transfer of the property means an act by which a living person conveys the property to himself or to any other living person. That means the property when it is being transferred to himself, to the specific person himself, or to any other living person. First, let's understand what do you understand by to himself. To himself means to own. It sounds little awkward, but yes, it is the truth. The property can be transferred to yourself. If I am transferring a property, I can transfer it to my name even. मैं खुद के नाम पे प्रॉपर्टी ट्रांसफर कर सकती हूँ. जैसे कि आपका बहुत सारे स्कीम्स हो जाता है, आपका कुछ योजना हो जाता है, जैसे कि हाउ टू से इट, डिड यू हियर अबाउट द पेंशन स्कीम? यस, when you provide the when you provide the pension, when the government is providing you pension, at that time, you must have heard about the EPF system, that when you are getting paid for your salary, specifically for the government servant, and it is also applicable in the private services nowadays, that a specific amount of the money that per month 2000 rupees, 3000 rupees as the security deposit, it is being saved in the person's account itself. Okay. And the pension or that amount is being given later to the person after the retirement. Okay. So here we can talk that this is the transfer of the property by the person to himself. Take another example that uh, I am having a lots of the lands and a huge amount of the property, and I want to distribute the property to the other persons. That I don't want to take the responsibility of all the property altogether. I'm just tired of this, so I want to distribute my property in between the people. Okay. So when I want to do the distribution, I started doing it. I started giving the property to the other people. Then in the meanwhile, a big part of the property I have transferred to my own name. That means the way I am transferring the property to others, my property to the other persons. The same way I am transferring this property to myself. Uh, this usually happens when there is the joint ownership is present over there. For example, there is a big land when the joint ownership has been done by me and my brother. Okay, so when there is the division of the property, in for all the divisions or for all the transfers, the joint approval of me and my brother is needed. Okay, so me and my brother we both decided a part of the property should be transferred to us itself. So here we are entering into a contract with ourselves that we are transferring the property to ourselves only. With the signature of me and my brother, there is a part of the property which is transferred to my name and another part is transferred to my brother's name. Okay. So here with my signature, I am transferring the property to myself. That is called the self transfer. And this is possible in the Transfer of the Property Act itself. Okay. The next point, to himself or to any other living person. Any other living person means anyone, your living pet, your worker, your if you are a social worker, then for the social service, anything which is considered as a living being, as a living person, the property can be transferred to them. Okay, either to himself or to the living persons, or to himself and the living person. That means the when the property is being jointly transferred, that there is a transfer of the big amount of the property from me to other persons. There I am a party and the other living persons are also a party. That means I am transferring the property to myself. मैं खुद को दे रही हूँ and दूसरों को भी दे रही हूँ. That means if I am transferring altogether 10 acres of the land to a company, there I am also a party to the transfer to me and to the company. That means the in that 10 crore of the land, I have the equivalent right as of the company. Even if I am the seller over here, I am also here the transferee or the buyer over here. The company has the right on the property and equivalently I have also the right on the property itself. This is called the self-transfer concept itself. Then in this section, living person includes a company or association or body of individuals, whether incorporated or not, but nothing herein contained shall affect any law for the time being in force relating to the transfer of property to or by any companies, associations, or bodies or individuals. So, when we are talking about the living persons, okay, living persons not only means the private individuals, you, me, he, she, these are the single personality, single private individuals. So when we are talking about the living persons, it does not specifically indicate that it is only indicating the living beings. Along with the living beings, it also includes or it also indicates the companies, associations, bodies, or individuals. There are the companies over there, there are the associations, there are the bodies, there are the individuals, there are the group of the people. Okay. So whenever I'm transferring to a property to an association or to a company, then in that case also the association or the group or the company will be considered as the living person itself, because there is no existence of the company without the living persons, right? जब एक कंपनी बनता है वहां पे देर इज द प्रेजेंस ऑफ द लिविंग बींग्स ऑल टुगेदर, है ना? बिना जिंदा लोगों का कोई कंपनी बन ही नहीं सकती। कोई एसोसिएशन जब बनता है इट इंक्लूड्स ए ग्रुप ऑफ द लिविंग पर्सन। व्हेन देयर इज ए कम्युनिटी इट इंक्लूड्स ए ग्रुप ऑफ द folk of the living personalities. So here, so here the concept of the living person not only includes the living persons only, it also includes the associations, the group of the people, or the company itself. It can be considered as a part of the living person. Got it? Next point, section 6. It speaks that what may be transferred, and section 7 speaks about the person who is competent to transfer. Okay. So first, let's read out section 7, then we'll go to section 6. So when we're talking about the person who is competent to transfer, what does it exactly speak? Every person competent to contract and entitled to transfer property or authorized to dispose of transferable property not his own is competent to transfer such property either wholly or in part, either absolutely or conditionally, in the circumstances to the extent and in the manner allowed and prescribed by any law for the time being in force. Okay. So when every person competent to the contract and entitled to transferable property or authorized to dispose of transferable property not his own is competent to transfer such property either wholly or partially. Okay. So the first line, every person competent to contract and entitled to the transfer of the property. The person who is entitled to do the contract, that person is entitled to transferable property, or the person who is authorized to dispose of transferable property not his own with the consent of the owner itself. Okay. So first of all, when we are talking about the first part, every person competent to contract. So who are the persons who is competent to contract? Under this, we have understood that the person who is not mad or who is not a psycho, who doesn't have any mental disorder, the person who is capable to enter into a contract, who has the better understanding about the requirement of the contract or about the things whatever he or she is doing. The third person who is not legally prohibited by the law, by the provisions, by the rules or by the regulations to enter into the contract. The person is not prohibited by the law to enter into the contract. Then we have discussed the person is not a minor. The person is above 18 years of the old. Okay. Then we have discussed the person is not a the person is not what is that called? Um, I'm forgetting the actual term. The person who is in debt. Okay. Who is incapable to um, just 1 second. Let me search it. Yes, the person who is a bankrupt. I forgot the word actually, the particular word bankrupt. The person who is bankrupt, or the person who is prohibited by law to enter into a contract due to his unlawful activity, there is the charges upon the person, and the person is prohibited by the court, by the law, by the police to enter into the contract, or the person is a criminal in nature. So, in all these circumstances, the person is unable to enter into the contract. When the person is has the below the age of the 18 years, the person is a minor, the person is incapable to enter into the contract, the person is of the unsound mind, the person is of the bankrupt, he doesn't have the money, the person is a criminal who is prohibited by the law to enter into the contract. So, in these circumstances, the person is incapable to enter into the contract, and when there is the absent of these circumstances and the person is capable to enter into the contract itself. Okay, so the every person competent to contract, the first point, and entitled to transferable property, and the person is entitled to do the transfer of the property. That means there are two situations when the person is entitled to do the transfer of the property. The first situation, either the person is the owner of the property, the property is of its own, वो उसका खुद का प्रॉपर्टी है, प्रॉपर्टी का मालिक वो खुद है. That is called the ownership. When with the property the ownership lies, the first point. And the second point, the person is competent to transfer the property even if he is not the owner, and that competency comes from the owner itself. ओनर ने ही उसको स्पेसिफाई किया है, उसको अलाउ किया है टू एंटर इनटू द कॉन्ट्रैक्ट. द पर्सन इज ऑथराइज्ड बाय द ओनर टू एंटर इनटू द कॉन्ट्रैक्ट. Got it? So there are two situations when the person is authorized to do the transferable property, when the property of his own, or if the property not his own, then the person is allowed or authorized by the owner to do the transfer of the property. Okay. So in that circumstances, the person is able or capable to do the transfer if the person is a sane person, is the understanding person, is a capable person to enter into the contract. Either wholly or in part, the property can be transferred fully, in whole, or partially, or as a part. That means if I am having the whole 10 acres of the land, I can transfer the whole 10 acres of the land, or I can transfer the 2 acres of the land, 3 acres of 2 acres to some other person, 3 acres to some other person, 5 acres to some other person. I can do the partial transfer of the property. I am dividing it. I am not transferring the property as a whole. मैं एक साथ सारा प्रॉपर्टी का ट्रांसफर नहीं कर रही, उसी को डिवाइड करके एक पार्ट इसी को, दूसरा पार्ट उसी को, तीसरा पार्ट उसी को, मतलब I am dividing the property and transferring the property. Okay, that is the most important thing. And next, either absolutely or conditionally, that when I am transferring the property, I am absolutely transferring the property, that the ownership is totally all yours now to whom the property is being transferred. You have all the rights upon this property, so whatever the enjoyment you want to do on this property, you can do this. You want to use this property, you want to get the entitlement of this property, whatever you want to do, the enjoyment you do it, I am not going to oppose you. That is called the absolute transfer. But conditional transfer means the property is being transferred to you for a certain period. It is not transferred to you fully. Anyways, when there is the sale of the property, or when is the absolute transfer of the property, there should be no conditions left over there. For example, मैं मेरा घर जो है मैं आपको बेच रही हूँ. जब मैं मेरा घर आपको बेच दे रही हूँ, उसी घर पे मेरा कोई मालिकाना नहीं रहेगा. आई डोंट हैव ओनरशिप अपॉन द प्रॉपर्टी, बिकॉज आई एम टेकिंग मनी इन एक्सचेंज ऑफ द होम. मैं घर के बदले पैसा ले रही हूँ ना, तो मैं एक बार आपको जब बेच देती हूँ तब घर के ऊपर मेरा कोई भी हक नहीं रहता है. देयर देयर फोर I don't have any right upon the property when I am selling the house, and this is called the absolute transfer. मैं पूरा का पूरा प्रॉपर्टी आपको दे देती हूँ, उसी प्रॉपर्टी में मेरा कोई भी लेना देना नहीं रहता है. And the second situation, when I am transferring conditional, that means I am transferring the property and that is imposed with certain conditions itself. Okay, that means the property is transferred with certain rules, certain regulations. That is called the partial transfer. That means we know that when there is the mortgage of the property or rent of the property, that when I am giving my home as rent, then while giving the home as the rent, I am imposing a lot of conditions over to the tenant itself. That you cannot use this house for the commercial purpose. You cannot do any innovation in the house, you cannot bring this person in the house, you cannot drink in my house, you cannot stay out after 10 o'clock. Okay, so these are the restrictions, these are the rules regulations I'm imposing while doing the transfer of the property. Got it? So this is called the conditional transfer. This usually happens when there is the transfer of the rented property over here. This is what we discussed about the absolute and the conditional transfer of the property. And in those circumstances, to the extent and the manner allowed and prescribed by any law for the time being in force. So, most importantly, this section 7 says that when there is the transfer of the property, it must be allowed and prescribed by the legal manner. Whatever the manner has been prescribed over here, that if the property need to be registered, then it must be done by the proper registration process. If the property is being done by the written document, then the document must be done. Okay, when there is the renting of the property has been done, there is the legal agreement must need to be done. There are the certain terms and conditions that must need to be done in the written language, the written words, the terms and conditions of the house must be written, that if you are using this house, then you have to do this, you have to do this. So these are the fixed regulations that has been mentioned, that has been described while doing the transfer or while doing the uh, property requirement transfer things. Okay, so this is what we are discussing regarding the transfer of the property, that whenever the property is being transferred, it must need to be done regarding the regulated manner, the legal manner, the prescribed manner. If it is written that the contract needs a written document, then the contract must need to be done according to the written document only. It cannot done without the written document. It must be done with the proper rules, proper regulations, proper conditions imposed, and the understanding regarding the rules and regulations, the attachment by the persons, the signature, that is the most important thing over the transfer. Okay, and section 9, that is the most important thing, it speaks about the oral transfer. What does it speak? A transfer of the property may be made without writing in every case in which the writing is not expressly required by law. So when we are talking about the transfer, then you must ask me that the property, is it always necessary that the property is being transferred through the written form? The answer is no. The property does not require to be transferred written form always. It can be done through the oral transfer. So, what is oral transfer? For example, I am telling you that I am going to give this 5 acres of the land to you as a gift. Hereby, I am orally transferring the property to you. Just take an example of this. Usually, everything should be done in the written form, but sometimes some kind of the transfer can be done orally. जैसे कि for example, there is a person who is at the deathbed, okay, and he has not done any kind of the uh, division of the property before his death. So before his death, when he has been asked about the property transfer or his last wish, he told that I have certain wish regarding the property and मैं कुछ बोलना चाहता हूँ. So what happens over there is a recording has been done about the property delivery or the division of the property, he told that the land, whatever I have, the 5 acres of the land I have, I want to transfer it to my elder son, and this home where I am staying, where I am dying, I want to transfer it to my younger son. This is what this person said and died. Okay. So according to his last wish, did the person had the sufficient time to write into the agreement, to enter into the agreement, to do the sign, to enter into the writing things? The answer is no. The person did not have the sufficient time to do such activities. Yes, he didn't have such time to do that. So when the person was incapable to do certain kind of the things altogether, what he did, he just told it and died. Okay. This is called the oral transfer. यहाँ पे क्या होता है ना, वो लिख नहीं पाता. The transfer is of two types. First is the written transfer. Second is the oral transfer. Written transfer, we all know that when the things has been done in a written form. But the oral transfer is जहाँ पे आप बोल के किसी तरह का ट्रांसफर का एक्टिविटी कर देते हो. This is being done in the verbal activity, in the verbal form. That is called the oral transfer. Okay. So what may be transferred and what may not be transferred, what kind of the property it can be transferred and what kind of the property it cannot be transferred, it is explained under section 6 of the Transfer of the Property Act. Property of any kind may be transferred except as otherwise provided by this act or by any other law for this time being in force. Okay. So what does it speak? It speaks that property of any kind that may be transferred except as otherwise provided by this act or by any other law for the time being in force. Okay. So under section 6 of this act, there are specific criteria has been mentioned, specific type of the property has been mentioned, which cannot be transferred to any other person. So according to the Transfer of the Property Act, except this kind of the properties, all other kind of the property is transferable in nature. That means the proviso or the kinds of the transfer of the property that is mentioned in section 6 of the Transfer of the Property Act, except this, any other kind of the property is being transferable in nature. The first point, the succession of the heir apparent. The second, the mere right of the re-entry of the breach of the condition subsequent. Third, the easement or the dominant heritage. Fourth, the enjoyment of the owner of the personally, when there is the personal enjoyment of the ownership of the property. Then comes a mere right to sue, a public office when there is the stipend in the military level, air force and civil prisoners that cannot be transferred. So these are the circumstances when the property cannot be transferred. So except this, in all other situations, the property can be transferred. Okay. So when we are talking about the heir apparent, so what do you understand by the heir apparent? That is a part of the space succession. Okay. I have already mentioned you that this Transfer of the Property Act is not applicable to the succession. That means the hereditary transfer, this is not applicable when there is the transfer of the property to a future person, someone who is something which is not in my control right now, but I am expecting that in future I am going to get that property in my hand. For example, I am having my father's, I'm the son of a very rich father, but the property is not my name right now. My father has not transferred this property to me. But I am expecting that after the death of my father, I am going to gain the ownership of the property. That is called the space succession, the future succession that cannot be transferred. So about that, we are going to talk in details in the next class. We can wrap the class over here. See you all in the next class, guys. Till then, thank you. Take care. Bye bye.